how we are called to act on behalf of our clients and the communities we serve, and where we want to put into our time. We are certainly, a rights enforcing people. We're an access to justice people. We hear those terms a lot. But in our founding moments as a legal services movement, we were more than that. And it is not that either rights enforcing or access to justice is lesser activity. It is very necessary and very important activity, and we must be about that. But we were born as a legal services movement with a broader purpose. And the history of it was, there were old line legal aid societies that existed, starting with the Legal Aid Society in New York City, and ours in Rochester. Susan B. Anthony was among the founders. And they were about making sure that at least some people, because they never could serve everybody, could get their rights enforced under law. But the notion of the legal services movement was broader than that. And we were created as part of the war on poverty, and we were created to be a rights-creating people. We were explicitly modeled on the NAACP Inc. Fund, or what is now the Inc. Fund, was then just the NAACP, whose quest was to end de jure segregation in the United States. And our mission as an early legal services people was to end poverty. And when I came into legal services in 1975, a really long time ago, people were writing mission statements that said, our legal services program will end poverty in Memphis and Shelby County by 1990. I mean, I saw that mission statement. I know the person who was instrumental in writing it. And the idea was we were going to use the law to end poverty. We were going to strike down all the things, and that is not a stupid and irrational vision. We have come very close in this country to ending elder poverty. Poverty is constructed. It is something we choose to have by the regime of laws, by the regime of rules that we have, and we can end it or we cannot end it, and like that. So we were initially going to end poverty, and there are law review articles that, set out the 10, lawsuits that we were going to bring to end poverty. Google or go on Westlaw and look at EdSpar and the article in the University of Pennsylvania Law Review that did that. And we were going to do it by both creating procedural justice, and that procedural justice is going to be that sort of due process people. We were going to create institutions that were so fair that people didn't need a lawyer or a paralegal at their hip to get what those institutions were supposed to provide them. They would not be subject to the irrational whims, because back in those days it was the irrational whim of the caseworker. Oh, Mrs. Smith, you're not doing enough, we're not going to give you an allowance. Mrs. Jones, we're going to give you an allowance. But there weren't schedules, it was just, oh, what do you need? Well, maybe we'll give it to you, maybe we won't. And it was, standardless and like that. And so we were going to create this society that was going to be both procedurally and substantively fair. And what's it mean to be a rights-creating people, and how do you do that even in a world of LSA restrictions and stuff like that? It's easy for us at Empire Justice, go to class actions, do legislative and administrative work, we can, do some of that stuff. But how do you do that in the world in which you live, and like that? And I think the biggest learning I've had is that we do it by telling stories, by telling and bringing to the mind of decision makers the lived lives, the rationality of those lives, the circumstances of our clients, who generally, actually, make very rational decisions in their own sphere. When I first came into legal services, the warranty of habitability was brand new in housing. And I had a map of Ulster County and every justice court, and I was going to get every justice court in the county to recognize this brand new warranty of habitability and then apply it even when I wasn't there, because I wasn't going to be there for everybody. But if they understood it and they recognized it and the judges were educated on it, then wouldn't they just apply it? That's a year out of law school. What the hell did I know about how the world works? All full of belief as to the possibilities. And I go into this trial, into my first warranty trial, and I got my client on the stand, and they're talking about terrible conditions. The health inspector has testified about the terrible conditions. I'm done with my direct examination, and the judge says, well, I got a question for your client. I can't object to the judge, I guess. So the judge says to my client, well, did you tell the landlord? And good lawyer that I am, I said, Judge, it doesn't say anywhere in the warranty they got to tell the landlord. That question is essentially irrelevant, Your Honor. Well, I'd like to know. And the answer was no. And I'd been trained by Irving Younger in cross-examination, and one of Irving Younger's rules was never ask a question you don't know the answer to your witness, because you could get surprised and unhappy and like that. So I don't ask the question of my witness on the stand. I wait until afterwards, and I said to the client, well, you said you didn't. Why didn't you? And the client said, well, because the last 2 times I'd had problems like that in places that I lived, and I told the landlord, they kicked me out. It was before, there were any anti-retaliation protections in New York State. And, and if I'd known the answer to that question and provided the answer to the judge would have liked it a lot better. I think it would have gotten a better award for the client. We forestalled the eviction, but, at the end of the day, the damage award wasn't what I would have liked. And the point is that my client was making a very rational choice in the frame. But I didn't know that. I lived in college housing as a renter. I lived, in housing owned by a Smith Corona engineer in downtown Hetherington. I called my landlord and stuff got fixed. Maybe not as quickly as I liked, but stuff got fixed. And I think that was probably the judge's life experience. But that isn't our client's life experience. But if the judges don't know that. And when I first came to Rochester and we had a housing unit, they were settling all their eviction cases. And I said, gee, that's interesting. I was trying a lot of eviction cases in the Hudson Valley. Why are you settling the eviction cases? We're getting great deals. I said, how do you know you're getting great deals? We know. We're getting the best deals. I said, well, let's have some fun. Let's try some cases. You do them, I'll second chair them. And we started using physical, real demonstrative evidence. We did a sewage in the basement case. We had a mayonnaise jar with a turd in it, and put it in evidence. Taught the lawyer how to lay a foundation for putting the turd in evidence. And I put the smell in evidence. Joe put the smell in evidence, actually. We had a roaches case, and Hannah Cohn put out roach motels and brought them full of live roaches into the courtroom stock. And we're trying this case to a Rochester jury. Well, in Rochester, because of basically race discrimination, but we won't talk about that, the city juries were a county-wide pool. So we had these suburban housewives, they didn't know what it meant to have roaches in your house. They took a look into that roach motel, and all of a sudden they knew what our client was experiencing. They understood in a way the words couldn't. The whole thing was with Donald Sterling. everybody knew that Donald Sterling was a racist. You listened to, but when you heard the language of Mitt Romney and the 47%, you hear the language, you possess the physical thing, and you understand more about the client experience, and it's those stories. There's a tremendous author whose work I love. His name is Drew Weston. He wrote a book called The Political Brain. And the political brain is about how you change people's minds about what they believe. Weston's not a political scientist. He's a neuroscientist. He looks at people's brains, connected up to machines. And what he says is we all have these filters. And we filter information when people tell us things that are inconvenient to what we believe. So if I say to you, it is a terrible tragedy that only 47% of the entering students in the 9th grade class in the Rochester City School District will graduate with a diploma 4 years later, and only 5% of them test as college ready. Many of us in this room, we say, oh, that's terrible, we gotta fix the school system. But there are a whole other group of people, including some people in this room, who would say, gotta fix the parents, gotta fix the kids, gotta, because that's the filter through which they take in and process this information. And Weston shows that people actually are terribly guarded against information they don't like, that disquiets them. And so what Weston advises, and there's some pretty good data that backs this up, is that you go through this multi-step process. And the law provides us the first of those steps. The first thing we talk about is a shared value. Every child ought to have the opportunity to succeed in life, no matter how meager his or her, state at birth. We can walk out on Main Street and Bill can start asking people that question, and he's gonna get 95% people gonna say that, right? Justice should be equal for everybody. Probably get 98% of people. Only the 1% would say no. And like that, there are these values that people, will line up with. And then what you do is you tell a powerful story. Short, not too many details. We lawyers like, don't tell too many details. And short, powerful story about how that isn't happening, that points out what you believe the cause to be. So, it's the cause is the school system, and here's what's wrong with the school system. And then you say, we have a solution. When we tried to end lead poisoning in Rochester, we dropped it from 1,600 kids a year to now 200 kids. We talked about, every child having opportunity. We talked about the notion that that it wasn't happening, and here's what was happening to kids. And Ralph Spezio, who was the school principal, would tell these powerful stories about these kids who were lead poisoned and how it just devastated their ability as learners, and by the way, affected the ability of other kids in the class to learn. And then we had it's really simple. You have to do three things. You have to find the houses that are likely to poison them. You have to fix them safely, and you have to fund the fix. Simple. Now, there's a lot underneath it. It took a lot of work to get it down to find the housing, fix it safely, fund the fix. But there was a simple, rational, hey, that makes a lot of sense, right? And then you tie it back to the values. And if we do that, then every child in Rochester will have a fair chance at succeeding in school, succeeding in life, being a productive member of society, and like that. And that 4-part thing works in arguing policy, it works in arguing law. The law often provides that first thing. What's the value, right? We're going to provide due process under the law. We're going to provide equal protection, and like that. But it's the powerful stories. And the place where I went wrong, and I remember watching it happen, like a freaking train wreck in front of me, is we were doing a welfare budgeting case, and my colleague Ken Shiatani was arguing it in the Second Circuit. And we were absolutely right on the law. No question we were right on the law. But it had become about grammar, parsing sentences and where the comma meant and stuff like that. And the people and the story of the people had dropped out of the case. And the story of these distant relatives who had taken in this nephew and therefore should be rewarded for doing this by having a decent allowance from and a decent budgeting methodology from the welfare department, that wasn't in our papers. Because we were right on the law. We, all you had to do was read the statute. Well, they didn't read it the same way we did, and we got our butt kicked. And around that time, I went back and I read the briefs in Goldberg against Kelly. And for those of you, who studied administrative law, Goldberg against Kelly is the great administrative law case that went to the Supreme Court that said property right includes public assistance benefits, and that you can't take them away without certain due process protections like written notice and an opportunity to confront and cross-examine and make oral, not written presentations. They have to be tailored to the capacity of the people who are being affected, impartial decision makers, a record, so that a court can review it. And, oh, by the way, if somebody's already achieved this property status, you can't take it away until they've had an opportunity to have this hearing and this impartial decision before the benefits stop, at least when it's core benefits, subsistence benefits, Maslow first tier benefits, like public assistance. Well, I had occasion around that time to go back and reread the record in Goldberg against Kelly. And there were 11 powerful stories, including people passing out in the waiting room at what was then the New York City Welfare Department, now Human Resources Agency, that primed the court to understand what was in it for the clients, what was at stake in this matter. And when we did the transit access case a couple of years ago that lost us our IOLA funding, temporarily, we're back. But the then IOLA board chair was the chair of the transit authority. And funny thing, there were other more worthy grantees. But when we did that, we consciously chose 11 different plaintiffs who had 11 different needs for paratransit. And not just the typical people with disability needs. Yes, somebody needed it to get to the doctor. Yes, somebody, needed it to get to programming. But we had a plaintiff who needed reliable transportation to work. We had a plaintiff who needed reliable transportation to serve on the vestry of her church. We had a plaintiff who needed reliable transportation to go out for a date. We had one who wanted to go shopping. We put in all of the aspects of the lives of people with disabilities, the myriad aspects of the lives of people with disabilities that we could, so that a judge sitting up there would not create his, because that was before Judge Wolford, his own stereotype about who people with disabilities are and what their transit needs might be and like that, and come to a wrong conclusion because he didn't understand the full range. So it's thinking about how do you create this understanding of the lives of the clients, because in many cases, the reason the decision maker, whether that's a judge or a legislator, goes wrong is not out of affirmative animus, but out of what we've come to understand now is implicit bias. And that can be implicit racial bias, that can be implicit disability bias. There are very few people who hate people with disabilities. There are some. There's some people who are profoundly uncomfortable around them, but there are very few people who hate them and want to get back at them. But people make stereotypical judgments. People assume that they understand the lives of people with disabilities and then make decisions for them that don't make any sense in their lives because we haven't done our job of educating people about, decision makers about what those lives are like. So we're called to do this work of expanding rights through using the most precious thing that our clients give us, which is their stories. The stories of their lives, which are sacred, and which they put in our hands, and which I've seen some of you use to great effect. I was in the appellate division, watching one of the AT cases on the day that we argued the Williams case. We won. Congratulations. But those are the precious things, and this procedural piece of it. What's this role of procedural due process? The procedural piece is around this notion of, the test says, first of all, the processes have to be tailored to the knowledge and capacity of the people who are being affected. The form of notice has to be notice that's meaningful notice. That's the word that's used. Notice that the people who are going to get the notice can understand. I mean, I have a hard time understanding some of the notices that our clients get. We have some work to do here. And like that. So, I think that's sort of, we have to think about the meaningful part. We have to think about all of the stereotypes and biases. There's Lucy White wrote this incredible article, actually in the University of Buffalo Law Review, about Mrs. G and the Sunday shoes. And Mrs. G was going to a welfare fair hearing, and Lucy was representing her. And it discusses the different discourse styles of women and men, and how the law of evidence about what judges are told makes testimony credible, what we lawyers are taught in law school makes testimony credible. That law grew up in the time when only men could testify. And so it's gendered in its expression. It's gendered in its, and there's a fair amount of research that says women are much more accommodating. They try to accommodate other viewpoints and find in their own explanation of events an expression where both parties could possibly be right. And that can lead women who are testifying to change position from when they testified at deposition, from what is in the notes of what they told the caseworker. And as a result, judges applying the standard rules, which weren't created with women's discourse in mind, can say, well, that's not credible. You changed your position. Subtly, but you changed it. Women are much more likely in their discourse analysis, when you look at their discourse, to express concepts relationally, not in these linear, I am absolutely sure and I'm going to go to the death, kind of narratives that, are the dominant male discourse style. Now, not all men use that style, and not all women use the dominant female style. But there's now, what we used to call shepherdize, but now Keysight or whatever, follow up on Lucy's research, you will find there's a fair amount of research out there now that looks at how that affects outcomes. And so, as we're thinking about fairness, we need to understand due process. We need to understand these concepts and be prepared to make the same kind of cases to decision makers about discourse that the criminal defense bar has been making to decision makers, and now with some success, around the unreliability of cross-racial identification and other things, where the science says that fair results, accurate outcomes don't occur. And what's the value? The value is getting it right. The value is that any justice system should adjudicate things fairly. And do we provide due process when 51% of people, and if we're in a welfare system, 70% probably of people who ask for fair hearings or more have their discourse style discounted, selected against, and selected against unknowingly. It's not like the ALJ is sitting there saying, damn, I'm hostile to women. The ALJ is taking the training that she or he got, the stereotypes, and making decisions based on it. So we're called to be this group of change agents. We're called to provide more rights. We're called to provide procedurally fair rights. And that's really broader than simply, the three-part Matthews balancing test of, what's the burden on each side and what's sort of the risk, what's the importance of the right. These things have to be more highly nuanced so that people can understand, well, why isn't this fair? Seems fair. It's in some ways a mirror of the debate, right, about whether or not we provide any additional benefit to those people who start behind in the race of life. There are some who say, well, no, if we apply the same standards to everybody, we'll be fair. And there are others who say, geez, applying the same standards when people didn't start at the same place means that we're going to get unfair outcomes and we're just going to perpetuate privilege. And so I think we're called to ask that set of questions in aid of our goal of expanding the rights, of leaving people better off. And I think the best indication of the power of this is look at what a wildly conservative Supreme Court, ain't nobody. Anybody in the room don't think this is a wildly conservative Supreme Court? Ain't no liberals anymore. Not as I knew liberals, There are centrists and there are some moderate conservative Democrats. And then you know, it's like off the table, so, you know, in the Supreme Court. I mean, you know, this whole notion that we call, you know, either Ginsburg or Sotomayor liberal, stacked up against Bill Brennan or Justice Goldberg or Thurgood Marshall, not really, you know, centrist. But the one thing that has worked, the one thing, the one civil right, anybody, what's the one civil right that has prospered and grown under this wildly...
Freedom of speech.
Well, that it has, but that's...
Marriage equality.
Yeah, absolutely. You know, the protected class that the Supreme Court has actually protected, other than the moneyed interest, right? And presidents whose last name is Bush. But the one class, or LGB, well, maybe LG, probably haven't gotten to the B, and certainly aren't at the T yet, right? But you know, lesbian and gay folks have actually done reasonably well in the Supreme Court. Well, why do you think that is? Anybody want to hazard a guess?
Well, Mrs. Windsor was a sympathetic story of someone who had worked hard to earn money. But the other piece of it, I can go off that you don't have time in this in the discourse because I've been involved in the gay rights movement for the last 40 years or so, but it's counterintuitive. I thought that the gay rights movement would be first you decriminalize,
Right.
then you do the workplace because that's kind of neutral, then you do housing, then you do maybe things with children, and the last bastion, which was not going to happen in my lifetime, was marriage equality. Absolutely different. People didn't march in the street very often for work or for housing. People went crazy. I'm a member of the Buffalo Unitarian Church. Everybody in the church, the straight people more than the gay people, Republicans as well. Everybody has a relative, a hairdresser.
You got it. You just hit it. And that's the deal. When the discourse about rights for lesbian and gay people started, the worldview of the straight community was Stonewall. It was drag queens. It was, you know, because people were closeted, and you know, understand why they were, right? Because it was dangerous to come out. Very few people who were straight, very few decision makers knew that they knew. Now they knew people, but they didn't know that they knew people who were in a protected class. And they knew them actually, you know, at more than just shake hands level, but the stigma, the risk was so much people didn't. Well, when people started having the incredible courage, the early people who had the incredible courage to come out, all of a sudden we discovered that there was this huge range of people out there, from the soccer moms at the cubicle next to us to, you know, all these people with difference. And so the stereotypes began to erode. And Supreme Court justices found out that they had clerks, you know, and all of a sudden this changed because the stereotype eroded. We get screwed up in our decision making when we don't know people and we think we know how to fix them. We think we know what they need. Ronald Reagan and welfare reform. Ronald Reagan believed firmly that the way you get productivity for rich people is let them keep most of their money, cut the taxes to them, it'll make them work better. Some of you are old enough to remember what Ronald Reagan did to the work incentives in the welfare program. Anybody want to tell us what Ronald Reagan did to the work incentives in the welfare program? He took them away. He didn't just reduce them. He took them away. Why? Because poor people don't need the same kind of incentives rich people need. They need different incentives. They need stick incentives. They need deprive them of benefits incentives. They need sanctioning. Well, aren't they people too? Do you lose your humanity when you lose your job? Are your values so fundamentally different? Can we agree that we have actually human beings here. One of the things I say as a boss is most of what I've learned about how to work with the folks in our office, I learned as a parent, most of the good stuff. I think there were some of these in other places. But most of the good stuff I learned as a parent. Not because the folks at Empire Justice are children, but because they're people. And children are people. And the stuff I was taught as a parent about what works, yelling at people don't work. Ever tried to get a kid in a snowsuit and get out to daycare and a meeting? I learned that yelling at people just don't work at bringing about the change you want in the world, right? So I think that's really the core of the message. We are certainly rights enforcing people, and we are certainly access to justice people. But at the end of the day, we have to be about being rights creating people. We have to broaden those rights. We have to broaden those rights in a way that there doesn't have to be a lawyer standing or a paralegal standing up next to everybody, because there ain't never gonna be. And we have to get back to our core mission of ending poverty. It isn't enough simply to make bad programs fairer. Lord knows it's important to make bad programs fair, but it's necessary, but it's not sufficient. We need to get back to that notion about what we do. One of the things I'm most excited about that Empire Justice does isn't a legal thing at all. It is, we run the community's tax preparation for low-income working families thing. And, the United Way used to do it, and then we took it over. And about 14,000 families every year get about $25 million in benefits. 500 volunteers every year work on that program, and that money lifts those families out of poverty. It lifts them out of poverty. And the thing that I love even more about it is the amazing people, Rita and Berta, who run it with the tax preparation as the gateway drug. We bring you in with the tax preparation. We then screen you for, do you have some legal problems that we might want to be thinking about, and are bad things happening to you and things like that. But mostly what we're about is about trying to move you from the financial margins to the mainstream. And we're trying to figure out, oh, you don't have a bank account? We can open one up right now. Do you have any savings? Oh, savings are really good. Would you like to have half of your refund in a savings bond, so that, and next year after you've done that, then we'll talk to you about having a savings account. And then we'll talk to you about entering the Cash Coach program, where you can work for 9 months with a cash advisor to meet the financial goals of your life. I went to the coach graduation last week, and the net swing over 9 months in the net worth of the average participant was over $3,000. Net swing in their net worth. And some people over $6,000. I mean, this is really amazing stuff about ending poverty, about giving people tools. And the night one of the coach graduates came in and talked about closing on her house that day. She closed on the day of the dinner, and what it meant to her child to have a house. It was amazing. So that's what we're called to do. We're called to end poverty by any means necessary, and using all the tools at our disposal. If people have questions, let's chat. Yeah.
I have awareness of how the progress of MCLAC and the pillar developed in response to the restriction back in the 90s, and you guys broke off and created a pillar. And as a litigator, you have, been freed from the constraints ever since the mid-90s of restrictions. And, we have this bifurcated delivery system. We are, of course, still, an LLC grantee, and, the profile of many of the programs have sort of changed over time to much more grant delivery work, and less effectively the law reform kinds of things. Now, that's not necessarily the effect of the regulations. It's more the effect of sort of the opportunities that have come down the pike in terms of what funding becomes available now, and how we sort of, in some ways, change from the pre-restriction era. Can you talk a little bit about what you see the opportunities for LSC programs to do impact work, where the areas are, and how you see that being done around the state and around the country?
Absolutely. So there was a guy who taught at Harvard Law School who had a theory, Gary Ellis, he ran the clinics around that time, who said, you don't just do law reform by doing class actions and stuff like that. You can do ordinary cases in extraordinary ways. And it can be done in any area of the law. Those landlord tenant cases that changed how the judges viewed the warranty of habitability and whatnot. We knew that we hit it when in state court, the norm back in those days was, you would turn in a memorandum of law and the judge would use it as a bench memo for the trial, and then when the trial was over, they'd give it back to you. Sheila Driscoll, one of the housing lawyers, gets a call after winning a trial in which she had done a really good job and done this bench memo with Reuben Davis, who was in those days a city court judge, and ultimately went on to the appellate division. But she got this call from Justice Davis saying, Ms. Driscoll, could you send a copy of the memo back? I want to be able to use it in other cases. So she'd done this trial memo. What he saw, he also tried the jury case with the Roaches. What he saw changed his mind in the way that what the Supreme Court justices have seen changed their mind on an important issue. So this piece about helping people understand the perspective, doing, when I was back in legal services in the Hudson Valley for a very brief period of time, I was doing some family law work on domestic violence cases. I started adding a cause of action for battery. This is back before domestic violence was all corrupt, and judges kind of poo-pooed it a little bit. In fact, they poo-pooed it a lot, and they didn't take it very seriously. So I started adding a cause of action for battery, the tort of battery, to my divorce pleadings. Did I think I was going to get a lot of money from the guys who were beating my clients? Hell no. But it was naming the behavior, because domestic violence wasn't viewed as, it wasn't guys' rights, but it was so ordinary if you were sitting as a family court judge or a Supreme Court justice that, there wasn't the revulsion that I think there is.
Boys will be boys.
Yeah. And that very aspect of naming, and then having somebody have to stand up and try to make a motion to dismiss that cause of action, and saying, hold it, as a matter of New York law, husbands lost the right to discipline their wives sometime in the 1800s, and no, this behavior is tortious and stuff like that. And it, so you do the ordinary cases in an extraordinary way where you're thinking about how do I create new meaning? How do I get people to look at the ordinary? I had one of my most disheartening experiences. I'm in the appellate division, and I'm watching a justice from Buffalo, who will remain nameless, in a case that's being argued by a legal services attorney involving emergency assistance for housing. And this justice, who I thought should have been wildly sympathetic, using my own stereotypical viewpoint of who the justice was wildly unsympathetic. And when I tried to figure it out, it became clear. This justice had sat in housing court. This justice had presided over tens of thousands of evictions. And so this notion of what it means to be evicted and why the state should step up and keep this from happening didn't compute. Boy, it sure made a big difference to me, because from my background, I've never been evicted, you know? And so getting evicted, that's really bad stuff. But if you've sat there and you know, looked down at people who are crying at you and pleading about, you know, where am I gonna go, and my babies, and say, sorry man, you gotta be out there, and you've done that 10,000 times, or however many times you gotta do it as a city court judge who sits in a housing part, you know, you turn a hard heart to that stuff. So we gotta help people see in new eyes. And there's lots of stuff you can do. I'm doing a lot of stuff with MICLAC now, you know, where we're doing system stuff, but it's within the regulations. So, you know, we sat down and negotiated an ADA policy, Americans with Disability Act policy, with the local welfare department, and MICLAC, and we were at the table. We're doing a limited English proficiency policy now. Does it help that there's somebody at the table from an unrestricted program who, you know, has done some cases that have cost them a lot of money and like that, and do they take everybody a little bit more seriously because we're there? Probably, I hope so. But this is a thing where, for the LEP policy, there is no private right of action. So if we're going to give people with limited English proficiency fair access to welfare benefits through this policy, and at the end of the day we do not negotiate a successful agreement, we're going to be filing an administrative complaint under Title VI with the Office of Civil Rights. That ain't a class action. That isn't illegal. That's not something that an unrestricted or a restricted LSC funded program can't do. So I think a lot of those things, you know, beyond just the ordinary, thinking about, you know, how through working on task forces. One of the things I say to welfare advocates is that everything you learned about the law in law school, to the ones who went to law school, you know, has to be turned upside down. You go to law school, you get this fancy degree, they tell you that you know, the highest form of authority is the Constitution of the United States, followed by the statutes, the U.S. statutes, the U.S. regulations, and then the state constitution, statutes, and regulations. When I went to law school, they taught you nothing about the sub-regulatory stuff, nothing about administrative directives, nothing about INFs, nothing about GISs, nothing about, you know, local handbooks, nothing about any of this stuff. But if you ask a frontline caseworker what's the highest form of authority, she doesn't have access to any of the formal law. In fact, the highest authority to her is what her supervisor told her last week. You know, so things that you can do that change the practices of the agency on how they deal with people with disabilities, people with language impairments, or not impairments, but just limited English language, and how you educate them. You know, we're sitting down in this negotiation. They're thinking about language as binary. Either you can speak English like 100%, and you know, the federal stuff says no, it's on a continuum. And for significant transactions, we have to provide more language help, and then you tell a story. And the story I told was, going over to Spain, renting a car, and then having somebody hit the car, and it's now, in a parking lot, and I've got to return it to the rent-a-car company, and I got to fill out some forms. Well, I had some high school and college Spanish, but I sure as hell am not going to fill out that form in my Spanish. I fill it out in English, right? Because I got an American Express card plunked down on that. There's some significance around that. And I want to have that transaction in a language where I know what the hell I'm saying. And, they got it. Because they've had experiences like that. It's figuring out where they are. How do you tell stories to relate their experience to our client's experience in ways that they can see that commonality? So I think there's lots of stuff to do, and I think it's in every area of the law. We think about, foreclosure prevention, or some of these things as being kind of cookie cutter. I don't think it's cookie cutter at all.
I just want to add a footnote here that to the examples that you provided, the ADA policy
Right.
and the civil rights complaint on the LEP are both things that our public benefits unit have done in the last, 3 or 4 years, most recently.
So you're ahead of us. This is great.
So, those are examples of things that we're doing.
Yeah. Yeah.
I'm sorry. Bryan, what I find is that when I talk to the folks at the Department of Social Services, the only thing that I can get them to listen to these days is a fiscal argument.
Yeah.
So I'm always sort of falling down into that argument. Is that a bad path to go down?
What do you mean
Is
by
it-
fiscal?
Like, I don't ever argue, people should get food stamps because they're hungry and they need food. It's, bringing food stamps into the county brings $1.83 of economic activity. Wegmans gets, the people who work. I mean, I'm always having these fiscal, or it's gonna save the county X amount of dollars if you do it this way. It's not because that's what the law says, but rather it's gonna financially help you, the county.
That's maybe because they have a bigger picture, though. And I think that's what sort of gets lost. That's the.
I always find myself there, and I don't know if that's a smart way to go, or.
So, I think that it's critical to understand the decision maker and where they are. So, it's unlikely that you're gonna walk in and make some argument to Justice Thomas on a case involving race that's gonna change his mind, right? Just not likely to happen. So knowing who your decision maker is and knowing, there's nothing, in my view, wrong about making an argument that aligns what you're doing with something that matters to them. So I'm always making arguments out of cost savings and pragmatism and stuff like that. What I try to remember to do, and sometimes do and sometimes don't, and like that, is couple those arguments with the dignity argument. Because I view this work as we're in this for the long haul. I will tell you, my personal life crisis, midlife crisis, it wasn't about, oh God, I went into legal services, I should have gone into the private firm and I would have had my boat and my Jaguar right now. And so let's go back out and buy a Miata because that's gonna, be affordable and replace the Jaguar. Or, toss my wife now at 43 years away and trade up to the newer model. None of that was in my midlife crisis. My midlife crisis was recognizing that we weren't going to end poverty in my lifetime. And when I started out, I believed we would. I really believe that. Cornel West talks about being prisoners of hope. And I am in prison. He says you can't be an optimist. Too many bad things have gone on. You know about the Holocaust. You know about the history of slavery. You can't be an optimist, but you can be a prisoner of hope, which I actually told comes from St. Paul. But in any event, so I think you got to play for the long run. You make those short run arguments, but you're trying to educate people over time to understand. And so the line I use, I love to use this, when talking with people from the welfare, we both have an interest in getting it right the first time. from my client's perspective, the interest is, that they get the benefits that they desperately need, or they find out that they're not eligible and they need to think about their plan B. And from your perspective, it's very expensive, to erroneously turn people down and have fair hearings and have re-apps and da-da-da-da-da. So I try to frame these things in what are the dual benefits? How do you benefit? How does my client benefit? Because you never know whether the only thing somebody else cares about is the fiscal, and you never know whether what you're going to say. I've had these experiences in my life, I don't know whether others have, where you've said something to somebody which you think is of little or no significance, you don't remember it, and 5 years later somebody says to you, you said this thing and it really made it, and turn, hello? No kidding, I don't even remember that conversation.
But I think getting back to what Penny was saying, and also what you've been stressing with these individual stories and stuff, because I always have to do this, I'm taking the other side and I'm saying, this is Buffalo where poverty is generational.
Yeah.
We are out in the field every damn day
Yeah.
with somebody telling us their silly story about how they got themselves into trouble. And half the time I'm like, you know what? I can't sell that because DSS is not going to say, oh, gee, I feel so sorry that you don't have a job, but I got a different
So
problem.
that's a really great point.
Like we
And
burn
the-
out.
And the story isn't about sympathy. Because, in fact, great trial lawyers will tell you, the juries don't award big damages for sympathy. In fact, juries often are put off by people who've been badly injured. They do it out of anger, with the defendant. So it's not about creating sympathy for your client. It's about, can you figure out why what you're asking for is rational, or why what your client did was rational? And what may seem rational, I did this case once, went to the Court of Appeals, where the issue was that my client had taken a windfall, that she had received low on public assistance, and she paid off her debts. Well, that's a pretty rational thing. You want people to understand why your clients do what they do, and more often than not, and there are times when it's totally irrational, I'll give you that.
Oh, there are a
But-
million times
but
when it's
when
perfectly
you
irrational.
when you ask the client the question why, and when we don't assume I didn't know why that client didn't tell the inspector or tell the landlord. I had to ask the why question. I had to be curious. And sometimes they give you something to work with and sometimes they don't. And I'm not saying that every time there's something to work with. But I am saying it isn't about sympathy. It's about how do you make it common interest. So when I'm saying getting it right the first time and getting it right timely allows somebody who's not going to get benefits to move on, or do an LEP, means that you've got the real story. And people aren't just telling you what they think you want to hear and nodding their heads and then making a mistake, and we've all made this big mistake. You're trying to find out what's in it on both sides, and the piece that's in it on our side isn't that this lady's got diapers, because you get hardened to that. And I've seen that, we did this case, the Canzano case, that went to the Second Circuit on home health aides. And actually on due process, one of the really big emerging issues in due process is going to be private parties who are contracting with the state to do the state's business, and deliver services in the ACO world and stuff like that. How much due process do you get there? And Canzano's a useful precedent there. Well, the two women who ran the county's home health agency, they were good women. They were nurses. One was the social concerns, social justice chair of her parish. But they had gotten so used to saying no, because they didn't have the aides. They couldn't get an aide to go out to Holly. They began to blame the victims. And they were so defended about that. And they needed to do it to go to work. You know, it wasn't, you know, and they lost the compassion because they had to sit across that desk too many days with some mom sitting there saying, but how are we gonna take care of the doctor says she needs, you know, and they couldn't deliver on it. And you know, like the book says, their hearts had become hardened. Harden not thy heart. And that hardening of the heart, we weren't gonna break through that. That's where, you know, you need that power of talking to judges who haven't heard millions of those things and putting it in these frames and these rationalities, and like that. Because there are a group of people who you can't connect with because if they were to be human in these situations, they would have to quit.
Yeah.
They could not, and I know some of them who did quit,
Yeah.
you know? So that's how I think you do this.
Yeah.
One of the things that came up when you were going to speak is that we would find some inspiration to keep going. And when you say that you've been here 39 years,
Yeah, something like that.
something, and I would think most of the people are gone who were there then.
Yes.
And what legal services was back in the 70s. For one thing, it wasn't something that people could make a living wage at. For many people, it probably wasn't good health insurance. And I'll tell a story about someone who was probably a dear friend of yours. I had a friend named Mary Ann Roby, and her life partner was a man named Hugh Brantley.
Yeah.
And Hugh, you probably knew better than I did. He was in UB when I was in law school. And Hugh worked with migrant farm workers, and he and Mary Ann had a baby, Jimmy, and I would travel out to the town of Wyoming to see them. And one day I went there, and they'd been up the night before, and someone with a gun had come to protect them because the growers had threatened Hugh's life, and Mary Ann was there with Jimmy, and everything passed over. But going to legal services didn't used to mean independent health insurance, and it didn't mean a salary you could almost live on, and it didn't mean a whole lot of days off. For the most part, these were 60s and 70s leftists, some of them religious, some of them far to the left, like the Weathermen. Right now, legal services is a job. We have a very hard-working administration who are here into the evening trying to figure out which boxes on grants, trying to figure out if someone's timekeeping is a couple of hours short, because if we don't report everything properly, we won't get paid. And we've gone to grow up and become parents and grandparents as you have, and people who were concerned, and
I'll show you the grandchild pictures there.
I don't know, I just want your reaction, because you were there then and you're here now.
So, and 9 of my colleagues are over 60 years old and still doing extraordinary work for us. Some are working part-time. Barbara Weiner, who some of you know, who does food service stuff, is so into grandmothering, and her grandchildren are in Germany, so she works for us 60% time, but 5 days a week, you know, some weeks, and 0 days a week because she's in Germany with the grandchildren, and like that. So, first of all, the people who we're seeing now at hiring are just staggeringly good. I mean, they are amazing, and they have fire in their belly, and they went to law school to do this, and that was not always the case. But that's who we're seeing now, and they are amazing. Second piece is, this is and can be sustaining work, but we have to meet people wherever they are, and we have to understand life cycle. You know, we are very proud of the fact that we were the second recipient of, maybe we were the first recipient, we might have been the first recipient, of the Greater Rochester Association for Women Attorneys and MCBA Family Friendly Law Firm Award. And it's not because we have low expectations for the devotion of our staff, but we understand our staff members have lives. And, you know, some people have issues now with parenting, and we need to understand that, and that we have to have some differential expectations when they're doing that. And now, in my generation, people are worried about those elderly parents, and spending some time on the road, going to visit or take care of and take to appointments and stuff like that. I said to a lawyer in private practice who was saying, "Oh, you guys are nuts. You just hired somebody who was visibly pregnant, and why in the world did you ever do that?" Well, first of all, it's a law, and secondly, because we see ourselves as making a lifetime commitment for that person. We want them to make that lifetime commitment back to us. And the law is a 40-year thing, right? And you can do it. And if you can keep people energized and thinking new ideas and give them the space to ask, well, how could we do this better? And what could we do to push the envelope? What are the 3 places we want to push the envelope this year? Then, so that they're just not being asked to close 26 cases or at level J, or whatever it is. I think, I can't believe on some mornings that people pay me to do what I do. It's pretty amazing, and there are tough mornings. I don't want to tell you that that there aren't tough days, but I think that the way you do it is being very mission oriented, by being family friendly and flexible, and you guys are doing all the right things here. You're talking about professional development and how do we keep fresh and how do we learn new things and like that. These are the building blocks of it.
Well, and I think one of the things, especially if you live in a place like Buffalo, and this is, my colleague Sharon has really been instrumental in teaching me how to keep it focused and what to really, it's overwhelming. There are so many poor people and they have
Yes.
so many problems, and it never ever ends. And
Yes.
what you eventually do is just throw up your hands and say, that's it, I'm getting another job. And what Sharon has taught me is, or I haven't learned it very well yet, but it's,
But you're working on it.
I'm working on it. Is to take one problem at a time and say, this client has told me, this is her legal problem, I will solve that. Never mind that the rest of her life is totally screwed up and this will probably make no difference and she won't like what I do for her. But having said that, solve that one little problem and you've done something worthwhile. So for most of us, we don't end up at the appellate division, and we're not making changes that are going to affect a great number of people. What we're doing is taking one difficult client and solving one of their myriad of troubles for this one day, and that's all we can do. And I think the problem is to do that and to say, that's okay, that's all I needed to do for today. That's good enough, and to keep that being enough, and to be able to say to yourself, you don't have to solve, I would like to solve poverty in Buffalo. Specifically, I would like to have great school systems where all the parents are really, really involved in their kids' lives, and, and because I think then we wouldn't have poverty in the next generation. And on my soapbox, I don't really think it's the teacher's problem, I think it's the parents' problem, and those are the parents that I work with. And again, if I can just slip in to one parent's portfolio this idea that, yeah, you gotta show up when your kid has something going on at school, that's good enough. Always Sharon's little window, this is the job, this is the tiny little job, get it done and move on.
And you don't know what effect you're gonna have on people's lives in the go for it. I had an amazing experience. We had brought it was a class action, but it wouldn't have mattered. Against the school district about the crappy education for kids with disabilities. And one of the plaintiffs was this young man who was a second grader, and he was in and out of the psych center, and the school district wasn't doing right by him. And I'm at a demonstration about the public defender system and like that, and what the county is doing with it. And this woman comes up to me and she says, "Mr. Hetherington, do you remember me?" And I said, "Ma'am, you look familiar, but no, I can't, quite honestly." And she gives me her name, and I said, "Oh my goodness, yes, I remember you." She was the parent of this kid. She said, "I want you to know that this child graduated from high school with a diploma. And if you're coming to the demonstration next week, I'll bring him along so he can meet you." You know, I didn't know that. I didn't know that this kid graduated. But it was happening, and these things are going on in the cosmic environment. You know, what you do may not seem to matter at this moment, and yet it may be the most profound thing. Connie Walker, who followed me as president of the bar, had done family court, abuse and neglect stuff representing parents. And she talks about parents who come up to her, today in the community and do that stuff. So I think there's that piece to it about that longer, time horizon. We're very oriented in Western thought to immediate gratification and what can you put down as the outcome on the form. And by being there for somebody at a critical point in their life, they may make change. And I think many of the most exciting changes, by the way, are at the intersection, of different areas of the law. One of the things that has happened in legal services and other parts of the law, we all become real big specialists, right? Mm-hmm. So, you're a housing specialist, you're a benefit specialist, you're a family specialist, you're a mortgage foreclosure specialist, you're a whatever. And one of the things that I love about Empire Justice is we have these people with these different talents and they're able to work, And my favorite story about it is Amy Schwartz, who some of you who do family know does domestic violence, gets a call from a shelter operator, not from somebody in the world of legal services. And this shelter operator has a resident who's about to lose her SSI. Why is she going to lose her SSI? You guys know the answer to that. She's going to lose her SSI because she fled her batterer. And her name is on the title of the house. And in the world of SSI, if you're not living in a house for a certain period of time, it is a resource. And the value of it then was counting against you. And she's a family lawyer, and she doesn't know anything about this, so she goes to see our friend Kate. Now, Kate is very smart and very talented and like that. And tells the story, and Kate says, "Damn, that's right, and there isn't an exception to it, there's not, that's what the law says, and, if she goes away, she's gonna lose that." But that's profoundly unfair. So Kate picks up the phone and calls General Counsel's office in Baltimore to somebody who she knows through, her work in the national organization, and says, "This is ridiculous. If we litigate this, you guys are gonna look like jerks. Do you think the President of the United States and the Commissioner are gonna wanna stand up and say that?" And he says, "Well, let me talk, I can't answer right away, I don't have the power, da-da-da," and calls back, I think it was the next day, and said, "Well, we can fix it for this client." And Kate said, "That's not good enough. Yes, you could fix it for this client, but you know what? There are thousands of other women in this country every year who probably face the same situation, and you better fix it for them too. Or else, And SSA, which had no power, to do this, sends out a national teletype 2 days later saying, "Suspend enforcement of this regulation with regard, because we never intended it to be applied to people." And it was that intersection. Amy couldn't have done that. Kate didn't know it was a problem. This has been on the books forever, right? But the domestic violence people and the disability people and the benefits people, people with disabilities are in housing and in the public benefit systems are often the canaries in the mine shaft. We need to be thinking about those intersectionalities. We need to be thinking about how do we make low-hanging fruit gains on some of that stuff, and moving past this thing where it says, "I don't know how to fix it, so I'm sorry, ma'am," as if like I'm freaking all knowing, And thinking, man, I work with these really talented, cool people. Let me go and ask, is there some way? Is there somebody? This seems so profoundly wrong. How do we get this thing done? Because we shouldn't stand for this.
Can I just dovetail into that, Wally? I think one of the clearest learnings I'm taking out of Bryan's presentation is the how of what we do when we're doing these service cases. You know, looking at what are the alternative ways, how can we, and you know, he's talked a lot about educating the people that you're up against all the time, educating, you know, the client, educating the magistrate, educating the judge by using the power of the compelling stories and not accepting that you've heard this too many times, because we all are, in this day and age, relegated to working for discrete funders. And we have little boxes that we have to work within, but it is not so much a box as it is a portal to go to something much more like systematic effort than just clicking another case by. So it's really the how, and as you've learned from Sharon, you know, one way of survival is to discreetly look at what you can do within that case, but really it's the how you do what you're going to do with that case that has the current potential change in it. And I think that's what Bryan's been expressing.
And it isn't in every case. I mean, so you can't do because of productivity realities and things like that, you can't do the extraordinary thing in every case. It's being mindful about, you know, Covey says begin with the end in mind. So think about what's the future state you want to bring about, and think about what are the cases that I can use. And the NAA folks were brilliant about that. Anybody know the story about how they built back to Brown? I mean, they didn't wake up one morning and go file Brown.
It took 20 years.
Class C started on the railroads. So they went back and started on the railroads, used the Interstate Commerce Act to integrate the railroads. Then when they did some housing stuff, and when they moved to schools, they didn't start with the elementary schools or the high schools or the college. They started with the University of Texas Law School. And they did the building blocks of precedent in cases most favorable to them, so that when it got to be time to do Brown, and that's why when we're heirs of the NAA, we're heirs of this process of building one step at a time, one precedent at a time, one education at a time, towards that future vision we have. Yeah, sure.
Don't you think, Bryan, that not only, you know, what we do while we, you know, because we're doing direct service, that every direct service that we do, even if we may not see it, if we give a client information, they may spread that information and it may sort of grow and grow and grow. And so while we're handling their discrete problem, we don't see, you know, years later, that maybe a whole community may know about the warranty of habitability hearing, or may know that you can go to family court and get an order of protection.
Yeah, I mean, and Judge Wolford, when she was sworn in, talked about taking her nieces past the White House the day that she testified before the Senate, and asking her nieces, you know, well, could you ever live there? And they looked at it and they said to her, they're, you know, 9 and 11. Well, yeah, we could be, our husband could be the president.
Oh.
And Liz said, you know, something wrong here, but they can't be it unless they can see it, you know? And so, yeah, when you see your neighbor get protected from her batterer, then all of a sudden that denormalizes battering in the community. It says to those people who believe that there is no protection, oh, there is protection. So that's that whole piece about the ripple effect of what you do, and that isn't in the case books. I have personal knowledge and did cases that, you know, had nice things in the case book and they didn't change behavior. you gotta both get the precedent and enforce it. Jim?
Yeah, Bryan and I, if you don't know, both, we intersected at Mid-Hudson Legal Services.
Which is
and I-
really back when
And I
Jim
inherited
was
a few
3.
of Bryan's files, and I know what they look like.
He's very discreet about what he
Yes.
can do.
But we always looked at it as a disadvantage when we were there that we didn't have, at least coming in, that we didn't have a priority system. So I had cases, you had cases
Yeah.
from just about every area covered by this office and possibly a few offshoots. And eventually Mid-Hudson started to prioritize, but they weren't big enough to have specialty units, and NLS, when I came here, had specialty units. I'd like to think that I and some of my colleagues who came from similar backgrounds were more well-rounded attorneys when we eventually wound up in specialty units because of that generalization. And that tends not to happen now, and I sometimes think that's a bad idea. I just wondered if you could comment on that.
I describe myself in some gatherings as one of the few remaining generalists in legal services, right? Because, you heard the bio, I practice in lots of different areas. I always practice with somebody who's competent in the area. So, I'll do a benefits case with Susan Antos and Barbara and Sima, or I'll do a housing case with Mike, or, but I'll do these cases with somebody who knows what the hell they're doing, and I'm a generalist litigator, right? And there is a real advantage to having done that, and one of the things we're actually looking at is how do we allow people who came in. Maggie is moving from foreclosure prevention over into non-mortgage consumer. And so we're looking at, and I was just meeting with a lawyer this morning who's thinking about moving from foreclosure prevention over into wage theft. So we are thinking about how can you get the advantages of specialization, and there are great advantages to specialization, and preserve those advantages while for that group of lawyers who do not want to be the absolute expert on something, moving on before they get so ossified in their career. Some of you, Jim will remember, Betsy Schneider. Well, Betsy was this magnificent lawyer.
Just so you know, my very first special education case was at the Second Circuit, but luckily I had her working with me.
Yeah, she was magnificent. But there came to be a time in her career where we asked her to change and take on some additional responsibilities, and it was later in life. She was terrified. And this notion that as a very mature lawyer and somebody who knew everything about,
Yeah.
what she knew about, that she would go back and be a baby in something, that was very scary. Now, I don't have a problem being a baby. I'm a big baby. But, I don't feel like I've got to be, know everything about everything. But I understand that can be off-putting for some people to go back and start over and to say, well, gee, tell me about that. I don't know about that, and like that. So I think that this notion of people moving around and whatnot, I do think if people move, you have to understand that at some point they get so committed to it, and as a resource to the office, maybe it's not prudent for offices to say, if Mike Hanley said tomorrow, I want to stop doing housing and I want to go off and start doing something, I'm not at all sure that we'd let him. I mean, as much as we love him and as much as he's given to us, but he knows so much about that it just, I'm not sure we could do that. Yeah.
As we get older, there are fewer absolutes. And one thing is, it isn't all, as it might have been in the 70s and the 60s, the side of the angels. For example, the groups, the coalition between women's rights groups and welfare departments has led to much greater enforcement of child support.
Yep.
Nobody has taken up the cause, which includes veterans, disabled people, schlumps, victims of the bad economy, mentally ill people. There's a whole class of people out there, mostly men, who are put in jail, who have their bank accounts frozen, who lose their driver's license and then get multiple tickets for driving without them. And while we have done an awful lot to help women collect, usually women, collect child support, we've made a class of people in various forms of debtor prison. Landlord-tenant. The old Polish couple who owned a place
Yep.
on the east side, now their son, who's struggling to live in Cheektowaga, is running it for them. The tenant, with their great legal services attorney, maybe it's none of yours, rips out the plumbing, throws yucky things down it, leaves a mess, has parties, is selling pot to their friends. Like, every action has a reaction. And I listen to conservative talk show radio all the time, and you'll hear people ranting about, I had that place on the east side, and one of them, free lawyers came in, and I couldn't afford a lawyer, and it's costing me a fortune trying to evict these people, and I'm just not gonna have any. Or, my tenant had Section 8, I can't afford all these fancier things. I don't know where we go with it, I just throw out, because I know you're a deep thinker, where we go with these dichotomies.
That's why I joined, that's why I wanted to join, Penny doesn't know this yet, but, her diversity, her diversity, committee, because there's that law that I discovered about language, that everyone who gets funding has to accommodate folks who speak a different language. And I know very well, because I do criminal law, that the police, who are now supposed to use the language line I know exactly what their reaction is. You folks fight all the time. We're there 18 times a month because you can't keep it together. Now you want us to come and spend 3 times as much time with you because we're supposed to be on this stupid language line, which means there will be less funding for our raises? Are you kidding me? And like, how do we make that work together? Like, we're so adversarial.
So there are a couple of, I mean, those are 2 very rich questions, but let me try to unpack parts of them. First of all, it is important to care about all poor people. You know, I mean, that's within our mission, right? And so, you know, today, literally, we're shipping a brief out of Rochester to the 2nd Department on the part of a respondent in family court in a child support matter about suspending, trying to get the 2nd Department to rule that a low-income respondent can have the interest on judgment suspended.
9% interest,
Right.
people can never, there's
Right.
usurious
So,
interest.
so, you know, we understand that, and I think that the sort of which side are you on things are tough. At the same time, you have to balance that off against, like in the world of landlord-tenant, where a lot of the authority is unreported. Maybe, you know, you do have to decide you're on the side of tenants and not landlords, because if this week you walk in and say, well, I've got these, you know, 3 civil court of the city of New York cases that I think you ought to rely on, judge, that support the landlord in this situation, you may be back in front of that judge next week with the tenant, and those cases may not be the ones you want the judge to know about, and so you may have to make some decisions with regard to some areas of the law that, you know, this is the side we work on.
We've done that, we don't defend accused abusers even when they're innocent.
Right.
We don't do any landlords.
And I think you have to understand, you know, we talked about process and substantive fairness. I think we have to be in favor of process fairness for everybody, even when it's uncomfortable. And some of the worst times of my life as a lawyer were when I was representing a tenant and the landlord was unrepresented. I felt dirty. And it isn't to not represent tenants, it's to, because most of the time it's the tenant who doesn't have the lawyer and the landlord does, it's to take that experience and then use it in discussions of civil Gideon to say, you know, I felt dirty when I was on the other side, and I'm sure that my brothers and sisters in the bar who represent landlords also feel dirty, and that's why everybody should have a lawyer, because we have, whether we like it or not, an adversary system of justice, and it doesn't have to be as adversarial as it is, and there can be collaborative parts to it, but at the end of the day, you know, the paradigm is everybody gets lawyered up and the truth comes out.
I don't think the truth comes.
No, I understand that often doesn't happen, and it only happens when we are equivalently lawyered up, and it only matters when all
What I
the...
learned in law school is there's no such thing as.
Yeah, well, and there isn't, you know, it can be true. You know, you said you do criminal stuff.
Yeah.
That witness who sits there and says, I saw her run away from the scene of the crime, she often believes that in her heart of hearts. And she is certain about this. She's not lying.
No.
She's telling you what she believes. That's why she's so hard to shake, and that's why, you know, the instructions about misidentification are so important, and removing the things that cause the misidentifications. But you know, they're not lying. People think the light was red, people think the light was green. They're not lying about what it was. They're telling you what they saw. But we see things through our blinders, right? Yeah.
I'm just thinking, because it sounds like you've done a lot of service work and a lot of
Yeah.
important work. And
No, the service work, please don't draw
No,
that.
no, I know.
Because the service work is important. I do individual casework from time to time now, and I recently did a name change for somebody who's trans in my church, and I get great satisfaction from doing that. That's important. It meant everything
Yeah.
to that person.
Yeah, I mean, I guess my midlife crisis is, and I'm not gonna do anything really big, because of all the little things, and I mean, not just at work, you work really hard here, and you go home, and you're constantly putting out fires with the elderly parents, with the kids who can't afford their bills and all that, but to get back to that, we all got back from housing court, and to give you an example of the fires, we had 36 to 40 people that a handful of us were to represent, start to finish. And there's a judge, and the issue is you gotta get done between 9 and noon. That's the goal. So you're going through this, and today was one of those days where most of the people I interviewed did not have the rent. And we're talking about not just 1 month, we're talking like 6, 7, 8 months, $3,000. And it's like, and you look at this and you go back to the poverty thing, and some of these people look at you like, well, I'm not gonna be thrown out, right? It's like, well, like they have absolutely no clue, and you get all done and you do the best you can. And the good part is, at the end of, whatever the 3 hours, we got done and we did the best we could. And many people are not gonna be evicted, or may not be evicted because of what we do, but at the end of the day, I keep thinking, why were there 36 people on one day, many of whom were $3,000 to $5,000 behind in the rent? And what do we do about that bigger picture?
Yes.
Because we don't have time to, at that moment, say, well, maybe you should, go to a housing seminar, maybe you should, do this the next time, or go to DSS first before, we just don't have time.
That's a
for
great
that.
thing.
So how do you balance all the bigger stuff with trying to put out all those little
So
fires?
I love the bumper sticker that says, think globally, act locally. And Covey does this really, I love this thing that he does, and he has these 3 concentric circles. One is our circle of control, and it's a tiny little circle. And then there's this broader circle that's called our circle of influence, which is bigger. And then there's this really big circle for the people in this room, right? Which is our circle of concern. Because we're really concerned about a lot of stuff. Bangladesh, racism, economic issues, you name it. Many of us, you look at our Facebook pages, we are freaking concerned. And we can be paralyzed by that. And we have to pick our spots. And we have to say, what are our gifts? What's the one thing? That's why I'm saying, if you're a housing unit, what are the couple of things we want to accomplish? We're not gonna end poverty this year. We're not gonna, change the minds of all the judges this year. What are our 2 or 3 affirmative agendas for this unit this year? That are in our area of influence. And they may not be in our area of control, because hell, we're lawyers, we don't control very much. We influence most everything, right?
Kind of like parents.
Yeah, right, you got it. yeah, right, it's very much.
What are you trying to say,
Yeah. Right, so it's like picking those spots, keeping our energy. It doesn't do anybody any good to have you burn out because, you know, you try to do everything at once and then you get discouraged and you do it badly and you're probably not very successful at it. Picking your spots, picking the stuff that's important, looking for the places in the system that matter. So I think disability advocacy around welfare sanctioning is one of the places where you can throw sand in the machine. You know, that's why we did Richard C. You know, to throw a log in the machine. But, you know, look for the places where you can gum up the gears that grind up our clients. And pick your spots. When I look at Empire Justice and what we've accomplished over the couple of decades, I think the thing that I'm most proud of is the way people have picked their spots. And people have had, you know, incredible, they have things lined up and they wait till the time is right to really put the press on. So, you know, we might get sanction reform this year, which will make a difference in the world of housing. Because, you know, a lot of those people don't have the right because they're out on sanction,
Because a lot of
right?
people say
And
it's
so,
under sanction,
yeah, so thinking about that, and Don Friedman, Lord, that man has been about doing sanction reform for decades. But he couldn't make it happen. We may not make it happen this year, but if we don't make it happen this year, we'll probably have it set up so that if the Senate flips next year, we get it. And so there's this piece, you know, Mother Teresa said, we're not called to be successful, we're called to be faithful. Now, she's not always my favorite example for things, but I think that that's true. There is this piece where we have to know what we stand for. We have to accept that we can't necessarily bring it about. We have to look at when is the moment that it cracks and we're able to run, you know, some of the stuff that are in the women's equality agenda that may or may not pass this year, 2 or 3 of those bills are Amy's bills. And if they pass, you know, it's because the timing was right and like that. We just got a bill, you know, the other day on, passed in the Assembly and the Senate on victims, you know, Crime Victims Day. Picking your spots, being in the right place, having the idea ready, and getting the ideas out there. You know, I got lots of ideas. I don't always write them down, I don't always publicize them. But thinking about what are the ideas that are important and getting them out there so that other people can take and go with it, so that you don't have to do it yourself, right? That we can do it together. Si se puede.
Oh, Bryan, thanks. Everyone good with me?
You know, it's so trite and whatnot that, you know, people go up to soldiers and uniform person, thank you for your service. But, you know, thank you, because this is hard work. And doing it with energy and integrity and passion and thinking about how to keep moving things forward incrementally. As the president says, a couple of singles get you a run, just like a home run gets you a run. Thinking about how to put a couple of singles together in your area of the law, rather than saying, oh, let's cure poverty tomorrow, but recognizing that we all ought to be about, a piece of us ought to be about what can we do to cure poverty, and all of us ought to be saying to everybody we know, we can end poverty. There is enough in this country to do that, and there are enough resources, and if they were properly distributed. And do you know that England has come very close to ending child poverty, even under conservative governments? I mean, they've come damn close to doing it. And as I say, we are very close to ending elder poverty. So We can do it. Poverty's constructed, as my wife, who is a post-structural, would tell you. And, you know, we can do this stuff. Keep your eyes on the prize and make the incremental moves towards it.
Thank you.